But this meeting is being recorded. We will go ahead and start with the roll call. And let me switch my view and see if I can have the largest view. All right, I don't think I have everyone on my screen yet, but we'll just go through the list. Is Erin here today?
I am.
Oh, hello. All right, I see Donna Brand.
Good morning.
Good morning. Deborah Dowdle. I have not been able to connect with her. All right, we will mark her as not here yet. I think I saw Kelly Evans join.
I am here, yep.
All right, good morning. Tabitha Fish. I'm not seeing Tabitha yet. Luciana.
I'm here.
Perfect. Jeremy Gibbons.
Present.
Thank you. Is Heath here today? I'm not seeing him on my list yet. Martin Herbst.
I'm here.
Okay, thank you. And I saw Chris Hill join.
Yes.
Perfect. Trina Chloe. I'm not seeing Trina yet. Natalie Otero.
I'm here. Good morning.
Good morning. Sabrina Owen, I see her present. Keith Rains.
Morning.
Good morning. Mike Ritchie, I saw you. David, I saw you. Good morning. I believe I saw Marissa join.
Presente.
Welcome. Linda. Linda, sure. I thought I saw
Yeah, I'm
her.
here.
Okay, perfect. I thought I saw you, but you disappear from my screen. And I believe I saw Jessica Thomas join.
Here.
Thank you. And I saw Amanda Thorpe just joined. And Monica Whitaker, I believe I saw, yep, I see her also.
Good morning.
Good morning. Okay. Thank you all for joining us. The first thing we have up on the agenda is the minutes review and approval. And just to clarify, that is the minutes from our last full guidelines advisory committee meeting. So the February 19th meeting, those were sent out with the agenda. Did anybody have any corrections or additions to those minutes? I am not seeing any. We will go ahead and accept those and post them on the public website then. I did want to make an announcement. I think we were just finding this out during the last meeting, but both Shannon Sporsine and Carrie Villa from the Department of Human Services have stepped down from this committee meeting. Carrie had accepted a new position and Shannon had to step down because of workload issues. So they are not ongoing members of this committee, but we do have ODHL specifically on the self-sufficiency side. If we have particular questions or topics we need to reach out to them for, we can do that, but they won't be attending the meetings on a regular basis. Okay, next, well, just to mention, and we'll go over it more in the work group updates. I did send out some of the committee meeting or the work group meeting minutes. We thought that might be an opportunity for this group to see those if you're not on one of those work groups, but wanted a little more detail on it. So we're going to start sharing that with the full Guidelines Advisory Committee. We won't be formally reviewing them in a manner of reviewing and accepting them like we do with our Guidelines Advisory Committee meeting, but that's something we're going to do going forward. So first up on the agenda after the business things is income disparities between child's households, and that is one that we moved to this meeting since Keith Rains wasn't available to join the conversation about that last meeting. And we did include in the materials that went out with the agenda kind of the fact scenario that was prepared for that. And I think Luciana was going to be available to maybe walk through sort of the calculator part of that a little bit. But Keith, I will turn it over to you at this point if you want to provide any additional intro before we do that.
Well, I think we have to deal with the philosophical idea are we trying to make sure that parents don't get upset because they have to pay support for their children, or are we more concerned with making sure that children's needs are being met? So, I mean, it's a philosophical decision we have to make because, if a parent is say apparently custodian having to pay support, there can be some upset. And my plan to enhance the possibility of someone paying extra support because of the difference in incomes, that could also cause some anguish on someone's part. So I think we have to philosophically decide whether or not our focus is to try and make sure that children are cared well for in both households. And if the decision is yes, that's our focus, then my proposal was to simply try and not equalize incomes, but to provide a little bit less income disparity by putting in an enhancement by simply taking the delta or difference between the household incomes and adding something to the support calculator so that the amount paid is more reasonable as opposed to extremely small amounts that could be transferred even in fairly disparate situations. So that's why I presented that scenario.
Thank you. I think as a starting point, our guidelines are not the goal of our guidelines, and the goal of this isn't to not have a parent pay support. I think it is to have the children be supported. So I don't think anyone would say that our goal is to just not have people be paying support. I think it's to be looking at the circumstances and have an appropriate order for the children.
I'm not sure that, just so you know, in our discussions yesterday, it came up, well, when we have one parent has primary time with the child, maybe we just create a zero order for support for that person. So, I mean, it's still
Okay.
percolating through.
Okay.
So,
Amanda?
Thank you. I think there's a difference, just to engage in this discussion, between providing for the children and trying to equalize the households. If I understood you, Judge, what one of your concerns is that income disparity can create a disparity in the relationships that the children have in both households with the parents. I think is part of how you articulated it previously. And I don't disagree that where one parent has the resources to pay for dance class, to pay for extras, to pay for other things, and the other parent doesn't, or the other parent, maybe the child is used to having their own room at one house, and then when visiting, the other parent has to share a room with a sibling or even a parent. Those, that kind of quality and standard definitely can, it is what we arrive at with a disparity between households. I just wonder whether that would be better addressed with a rebuttal factor than an equalizer so much, because I'm concerned spousal support would address this for some couples theoretically, or would be intended to, and that gets factored in. But then when it comes to others, when we're not factoring in length of the relationship and so forth, I just wonder if sometimes it might be a harsh result. And I speak to that as an attorney, and also as a parent who is the custodial parent that out earns considerably the other parent. But the income disparity is the other household also has a good income and much fewer financial responsibilities. So that analysis would be incredibly complex. I'm a lawyer with student loans and other debts that I took on or took out of my marriage, kept most of the debt because I had more of the income, whereas I make probably close to 3 times my co-parent who only has the standard every other weekend. And so, his money goes a long way. I'm very fortunate, and I count myself fortunate. So I'm not saying that there aren't some adjustments to be made here. I don't know that I feel a sweeping change is appropriate. I see it more as a rebuttal factor.
Thank you, Amanda. Jessica?
Hi, yes, I also agree it should be in a rebuttal thing instead of in the calculator. I just see, especially considering my own personal experience, I just see that being used to abuse the system by certain people. For example, choosing not to work in order to try and reduce child support already. So, choosing not to work and having your new spouse pay all your bills, but then in the income or in the child support calculator, it looks like there's there's a disparity in the household, but once you consider that the other person has all of their bills paid for by their new spouse, and so they don't need to, necessarily have any work in order to survive, so they can continue to pretend that they don't have any money so that they can not pay any child support. And I see that income disparity, like household disparity thing, becoming something else that can be used to abuse the system. And in a rebuttal where it's actually taking into account the specifics of that case, and that particular case is being looked at on its own, yes, that could be a solution in some cases, but I don't think it's a good idea to add it to the calculator, especially because of all the other variables, like, having an maybe they have a roommate situation. One of the parents, the non-custodial parent, maybe has, somebody paying all their bills for them so they don't have to work. So then they can pretend that they don't have any income, which is what's happening in my case. But I just see it being abused is my point.
Thank you. Mike?
Good morning. I do understand the point Judge Raines is trying to make. On the other hand, I think we have to remember that the underlying premise of the economic study on which the guidelines was based, and the guidelines, is to apportion the amount of money that an intact family would spend to support a child, to apportion that between the 2 parents based on their income shares. And in my mind, adding on a supplemental calculator to increase the amount of support is better handled with a rebuttal. I tend to agree with the reasons Amanda mentioned. Plus, I think that routinely trying to equalize the support between the 2 households does more than support their joint child. It ends up supporting the new spouse and any non-joint children that happen to live in the other party's household as well, which, I mean, philosophically, that's a laudable goal, but on the other hand, I don't think it's within the scope of our actual guidelines. I think that's beyond it. And if you have situations where the calculated amount is unjust or inappropriate, there's already a mechanism for addressing that. So,
Thank you. Linda?
I I disagree with the last few comments. I think that Judge Raines is observing a consistently unfair result that happens when there's a big disparity between parents, particularly when there's a close sharing of time. I mean, if you look at the presumed amounts that come out in his examples, and I've seen it over and over again, where there's quite a lot of difference in income, it's just a very, very small amount that the parent's receiving in support, given the ability to pay of the parent. So it's addressing a glaring, I think, a glaring problem in the guts of the system. And therefore, I don't think it's a rebuttal issue. I think the examples that the last few people were giving are examples of why a rebuttal would be applied if this was the rule, is to have 5% of the difference. It's not even close to equalizing incomes. 5% of the difference does not do that. And also, I think addressing it via spousal support is completely missing the point. It had nothing to do with the spousal support need. It has to do with whether it's a fair amount that's contributed to a household that's significantly less wealthy. So I think for these examples that he's given, if you look at the person's income and how much the presumed support is, it's not a big chunk of money for that person at that income. And so I really support this, any approach to try to address these examples. This one I particularly think is fine. It's a mild adjustment, and it brings the child support closer to a fair level.
Thank you. Keith?
Well, it appears that it's unlikely that my and Linda's and my viewpoint is going to carry, but if it is specifically articulated as a rebuttal factor, the disparity of income between the parents, that's better than what we have right now. And remember, many of the parents we're dealing with are unmarried, so spousal support isn't an option anyhow. So that's my thought. So if we're not going to be able to move forward with the idea of making a change in the calculator, then at least if it's specifically articulated as a rebuttal factor as opposed to just one of those, oh, and anything else, that's better than what we have right now.
Okay, and just before we continue, I just wanted to mention that we do have the comment in the chat that Jeremy put in about the court has authority to consider non-enumerated economic factors that are relevant to the needs of the child. But the factors that are part of the formula for determining the presumed amount, such as the income of the parties, may not be the basis for rebutting the presumed amount. And then he included a case site for that. So just wanted to call that out. Chris.
Yeah, but thanks for that, Jeremy. That was part of what I was going to say, was what road we go down with this depends. I think I've heard that case cited before, so you gotta, how that we would possibly build this in, I think would have to take that into account or whatever being the rules. But we are talking a lot of times about married families here, but we have to remember we have a lot of unmarried parents as well, keeping this. And I will just say that when we're looking at the best interest of the child, if you put right up front, if you do 50-50 parenting time, more or less, that there's not going to be child support paid, that impacts how one parent may go for parenting time. There is oftentimes I've seen where a parent hasn't, up until the point of child support being sought, spent much time with the child. But when they find out that if they get 50% of the time, that they're not going to have to pay anything, and unfortunately we still have that prevailing view that they're paying the other parent, not paying for the purposes of the child, that they're going to seek 50% of the time with that child, because that's automatic, that's going to right away get them to no child support. Whereas if they saw there's factors in there that income is still going to be involved a bit more, especially when you have a substantially more income, I think it would affect the best interests of the child overall. So I do support this being a factor in some way.
Thank you. Luciana?
Really quick I had another point, but I wanted to speak to the parenting time work group yesterday and that discussion about potentially ordering zero in some circumstances, is when the parent with the majority of the parenting time is also being ordered to pay support. And considering defaulting to 0 in that scenario unless someone is actively wanting, like the person with less parenting time is actively wanting the support. So I think it wasn't necessarily a sweeping, anytime someone has more parenting time, it would be 0, but just adjusting when we actually flip our obligations over. And I also wanted to just think a little more about, Keith mentioned a rebuttal factor that articulates this, and Linda talked about making the support amount more fair. And I'm wondering if we can pinpoint, when is the income disparity enough to be considering these things? Like what are we using to say that the current guideline is unfair? I think it's anecdotally, like people are seeing this on its face, but if we can articulate that and try to pinpoint what that is, it'd be easier to write something into a rule.
Thank you. Michelle?
So if I'm understanding Jeremy's note, they wouldn't be able to use the disparity of income to increase the support as a rebuttal necessarily. But if you included the disparity 5% rule, they could rebut that if it was unfair. That's all I was going to say. Based on the needs of the parent.
Or the needs of the child?
No, there's a rebuttal for where the needs of the parent, they can say, well, yeah, but if I pay this much support, I'm gonna be suffering. There's some kind of rebuttal for that. I don't know it off the top of my head, but if we did the disparity of income as part of the calculation, and that was came out unfair to a parent, they could then have a rebuttal saying, yes, I understand the reason for this, but.
Okay, thank you. Jeremy, did you have anything in direct response to that before I go to Keith, or?
I have just sort of a couple of thoughts that are more generalized, but if you want to come back to me, that's fine.
Okay, I'll go to Keith since he was next.
The idea that a parent actually starts to exercise their parent time means this plan would actually improve the child's lot by having 2 parents in the life rather than just one. Just a thought. But my thought is, if we put a rebuttal factor in, that'll take care of the Court of Appeals case, because Court of Appeals case there says that this is not a rebuttal factor, and we're saying now it is. So we're changing what the rules are, and so the Court of Appeals will have to honor that. So I'm less worried about that. And as to what the point is where this kicks in, if it's a rebuttal factor, it's going to be up to the court or the administrative agency to decide when that rebuttal factor is going to kick in. So my idea was to create something and then come up with a shelf under which we wouldn't worry about it. But if it's not going to be something, if that's not where we're going to go, then I'm not going to worry about that piece. Does that make sense?
I think so.
And if it's a rebuttal factor, we don't need to put a percentage in or anything else. We just say, you can rebut. If you want to put in the conversation in the commentary, I suppose that might be appropriate, saying that we're concerned about this happening and thought about this and decided to leave it as a rebuttal factor.
Okay, that's something we can look at further. Jeremy? You're on mute.
I pressed the wrong button. Thank you. I just have sort of a couple of general thoughts, and they're going to be about how we build the formula about fairness and complexity is one. And another thought is going to be about litigation incentives. So if we make the calculator more complex, if we add on a new fairness module to it, then it becomes more complex and it's more, and implementation difficulties are not obviously a reason not to do something. It's something to consider. But we also have to remember that one of the primary goals in our guidelines modification, I believe it's one of 4 goals listed, is that it be simple to administer and to understand. And if we have everything we have plus a new add-on, then you have just that much more complexity. Both for program administration and for people to use and understand the guidelines. So I suppose what I'm getting at there is that if the guideline formula that we have now is producing substantively unfair outcomes, then I guess the first question I would ask is not what can we add on to it, but what's wrong? What do we need to fix it? What's it doing wrong that produces substantively unfair outcomes? The second thing that I want to point out is about litigation incentives. One of the purposes that the parenting time curve that we have now serves is to give people, make sure there's no incentive for people to litigate over a few overnights of parenting time, because the change in your support obligation is going to be very small. So the idea is to make litigation about parenting time really be about parenting time. But if you take the formula so that at 49%, and it used to be this way, we would have one change at, I think, 25%, one change at 50%, and then another change at 75%, just a mirror image. And people would litigate endlessly over those few days of parenting time that it might take to get them up to having a credit at all, or to the special 50-50 parenting time plan, because that would benefit them financially. And so one of the things that we saw 12, 13 years ago was getting rid of all of those very specific incentives. So I'm concerned that anything that says, well, at this one point in parenting time, we're going to apply a different formula. Well, people who might really want 40% parenting time, yeah, you bet there's going to be lots of people are advocating for 50% parenting that time that they don't want, because they want a break on their child support, or they want more child support depending on the certain situation. So just as far as how we approach this, my suggestion would be, again, if there's something substantively unfair, let's say, what is it that we have now? What's it doing wrong? And how can we undo the wrong thing that it's doing and recraft that in a way that's harmonious with the rest of it and doesn't create incentives to litigate? Thank you.
Thank you, Jeremy. Linda?
Yeah, I love what you just said, Jeremy. Thank you. I think it is worth looking at what is wrong with it, because I think it is wrong. I think it really does come out badly in a large income disparity situation, particularly when there's a closer time sharing, and it doesn't have to only apply to 50-50. I think that Keith's examples happen to use 50-50 because that's where it's the most obvious problem. The other thing I just want to say is that you all know that the presumed amount is the amount that's ordered in almost all the cases. It's just people go with what the presumed amount is. Arguing a rebuttal is really difficult. And so solving things with rebuttals doesn't work when there's a pattern of unfair results that people have to argue a rebuttal for. So, I mean, most people, they look at the agency, the parents, the attorneys, they look at the result of the child support calculation and they go with it, because mostly it's fair. But this is an example where it's unfair.
Thank you. Kelly?
Yeah, I come from the perspective that and agree with a lot of what Jeremy says, and I feel like, and when none of us, well, maybe some of us or very few of us actually understand the math behind the formulas here, but we came up with this idea that the formula is fair and as much as it can be for everybody. And across the board, it's relatively fair, and we address the situations where it's not fair with rebuttal factors, which most judges don't want to deal with. And the vast majority of cases are based on the presumption of the correct number coming out of the formula. But basically, if we're trying to do what I have a problem with is that I don't see a threshold here. I don't see anything that says that we're not going to calculate an extra calculation, which basically means that, hey, what we're doing right now is not working, or it's right for some people but not right for everybody. These small cases here, these small ones where there's disparity of income. And so people may not like it, Linda may not like that rebuttal factors don't typically solve the problem, but I don't know that I see the problem. In 25, 26 years, I've been probably successful in arguing a rebuttal factor on one hand, maybe in court. And so there's definitely some consistency associated with that. There's also predictability. So, I mean, it sounds like, at least in terms of what I would suggest we do, is if we're going to address it at all, and I'm not sure we do need to do that, because even the rebuttal factors, the list is not exhaustive. The court can come up with other factors that they deem appropriate to justify a rebuttal. So if we're going to draw attention to it, then we probably need to explain a little bit why we're doing it, which again, I'm not completely convinced that there is something that we need to address here. But if we're going to do that, as far as the commentary goes, I still don't know if the impact is going to actually have any real life effect. I still don't see that judges on an administrative level or a circuit court level are going to suddenly interpret a commentary to say that, oh, now we've got this new rebuttal factor, so we're going to apply it to all cases, because that's kind of what it looks like. So I'm just kind of in favor of the status quo, and that's my position.
Thank you. David?
Yeah, I was just going to mention about the recipients. Financial literacy pretty much in Oregon is getting worse every year, and everything that we're doing right now, the calculations, and we have to take into consideration that some of the people, no matter how much income they receive, they don't know how to manage. And if the goal is to provide this in the best interest of the child, if a person is not able to manage cash flow or income, I don't see that as in the best interest of the child. So it's something that in any single case, if somebody cannot manage income, whatever they receive, then they're going to have an issue always. Yeah, that's all.
Thank you. Keith?
I think we have to remember that there's tremendous pressure on judges to go to 50-50 parenting time. We have to make written findings if you don't order it, if either party asks for it. Almost everybody's asking for it nowadays. And of course, there's a bill that people are aware of that may or may not pass that presumes 50-50 parenting time without written findings or not. So I think we have to look to that 50-50 model as likely to be the thing that most judges are moving toward, except under unusual circumstances. And that means the scenario I presented is not an unrealistic one or one that's unlikely to happen. It's very likely to happen.
Thanks for pointing that out. I think one thing is, if there is a statutory change that takes effect at some point in the future, that could also be something that a future guidelines advisory committee looks at, depending on the timing of a change there. So we would have that. And Kelly, I think your hand is just up from before. It didn't look like it went down. Perfect, thank you. I did see that Jessica put, actually, yeah, Jessica and Trina put some comments in the chat. And in particular, I think it's been touched on by the group here, of some of that. Jeremy did it a little bit on the arguing for more overnights, on a small level, if it makes a change in it. And also, there are some individuals who only go for either 50-50 or more than that, when they maybe don't really want that, but it is a financial aspect. I think there's some homes where some situations where that's good for a child and some situations where it's not. From a child support guidelines perspective, we're not going to be able to address the parents who the parenting time and the aspect of are they spending quality time with the child or not? And unfortunately, that's going to be outside of what we can address there. Marissa?
Yeah, I just wanted to ask, I think, you know, I'm here as a parent and it's a little bit of a struggle because this is not an area that I'm familiar with just as a parent. So when I hear you guys talking, a lot of it is like kind of if it's hard because you have to catch the terms and kind of follow because a lot of you know, work in it day in, day out, your judges, your lawyers. And so it's hard to follow. And I want to be able to contribute because it impacts me directly going forward. So if you could try a little bit to put it in more plain speak, that would help. What I'm getting from this or what I just think about, of course, is my own experience because that's all I have to draw on. And I know what I have experienced as the primary custodial parent and the one that has the higher income is, you know, an understanding that the other parent has a less income, that they frequently are unable to hold a job. But really coming from that basis of this is a child, we're trying to provide as much as we can for them, at least what's essential. You know, if there's extra things, then I'm the one that makes that happen. And the parenting time is the same where it's every other weekend. But when I first came into this, the response about the child support was you just want money. And so as we go forward and we look at what we're doing, you know, trying to make it manageable for both families. I just want to make sure that that part is fair. You know, I don't want to see a parent, you know, not being able to eat or do stuff because, you know, too much is being taken out from them, but also recognizing that this is for the child, whether you're together or not, you're trying to provide for your child. And so that's really all that comes to mind. I don't know how that affects, you know, the calculations, whether you do a rebuttal or not, but that's really what I think about.
Thank you. And thank you for the reminder of trying to use plain speak because we do have committee members here, but we do post these recordings also that other parents or practitioners or just members of the public may go and watch. So thank you for that reminder and for sharing a little bit more on those circumstances. And I think there's a couple of things that have been mentioned here of the situations where maybe a parent has in their new living arrangement, maybe they don't have to work because they have someone who's providing for them, or they may be unable to work due to a number of factors of medical conditions, dependency issues, criminal records, or just not a desire to do that. But I think there can be a combination of things there, and there can be situations of it's not someone willfully avoiding working to make more income just to avoid paying child support. So there's a number of things there, and sometimes there can be a combination of them going on in one particular case where it, you know, they all can be barriers to adequately supporting a child. So thank you. I think we've addressed most of the comments. So this started as a question of, do we want to run through the calculations or not? We had a really robust conversation. I think was it in the income groups that you did already run through these calculations or not?
We did run a calculation in the income group, and I believe healthcare coverage did as well.
Okay.
We did in the parenting time one also.
Okay. Would the group like to run through the examples that were included in Keith's handout, or not at this time? Thank you for that. Is a good reminder, particularly the parents in this group, whether you're there's several people who are parents that are not on the committee as a parent with lived experience, but there are opportunities to provide testimony in the legislative process about that bill. And if you don't know how to do that, I could share a link with you when we're done here. I don't want to have it be in the context of this one, but we are in legislative session, and so there are various bills pending, and that is a way to provide input directly on that. Jessica, we can follow up with you afterwards and share. There's a link on sort of the legislative process through the state legislature and specifically on the bill, so we can follow up on that. Okay, so I think we do have the case data report. So at least for now, given the time, let's move ahead to the case data report. And we can come back to the calculator in this one, or follow up at a future meeting if we want to go through the specific examples. So we do have Annie Engel and Luciana Fontanini, who are both child support program employees who helped prepare this report with work from a lot of other people, but I don't know if one of you is going to share or how you want to. Okay, perfect. Take it away.
All right. So the report that I'm putting up, I don't know if it showed up yet, is also on the Guidelines Advisory Committee webpage under reports. So you guys can look at it. It was attached to the agenda too. So you have lots of different ways to get to it. We are required when we're reviewing the guidelines, we have to look at how the guidelines are actually being used on real life cases. And there are certain criteria that the federal law requires us to consider. So several program employees together kind of try to come up with a way to find the cases, both orders run by the program and orders run through the courts, and look at those factors we're required to look at, and while we were at it, maybe a few additional factors, and then attempted to put that into some sort of report that might be helpful to this group. So I'm just going to walk through what's in this report, and hopefully folks will have a chance to read through it and apply it in the work groups, or if specific questions come up, definitely to ask them here too. But the gist of what we did was we pulled cases and got a sample of about 360 cases that were calculated from the courts or through the program. And the components we had to look at is at what rate were the orders entered in default. So with no hearing, no stipulation, no outcome, they just defaulted with the proposed order. How often did the self-support reserve affect the calculation? How often were rebuttals used? How often was income imputed? That's what they call it at the federal level. We say potential income in our rule. And then what we actually chose to look at in this was how often did we say, hey, parents are earning potential minimum wage without really any other factors to back that up, because that was one of the issues we wanted to look at within the income work group. And then we wanted to look at compliance in all of those areas, like how many payments or how much was getting paid on the orders that had these characteristics. So the first section of this report just has that out of our sample cases. We were also curious if it made a difference whether the order came out of the courts versus through the child support program. So we have a section where we look at those same components, but dividing it into program orders and non-program orders. We also looked at urban versus rural zip codes where the paying parent was living to see if there were differences between those folks in urban areas and rural areas. We actually did not see much of any differences between those two, which was interesting. There were some differences between preparers. Then, and Annie's going to tell us a little bit more about this in a moment, we went through compliance in a bunch of different areas that we just thought might be interesting to this group or to the program itself. We measured compliance in a very simplistic way. So it's not, when the program is considering compliance, we look to see, was the entire court ordered amount paid? Were arrears paid down? This sample really just looked at, did a payment come in after the order was entered? And that was just the nature of our project and trying to get through it. I think it would be very interesting, and Annie will talk a little bit more about it, to look at that one a lot more deeply. We also had a healthcare coverage section. We weren't super satisfied with the results of this because really all we looked at was what was ordered, and we didn't necessarily have data on what was actually being provided in a lot of those cases. But in general, these orders were entered between July of 2023 and June of 2024, and we looked at payments through August of 2024. So that's kind of the time period in the picture we have in here. And Annie, if you're willing, I'm going to jump down to the compliance area and let you just explain those charts. So if folks are reading them later, they understand what they're looking at.
Yep, definitely.
Maybe.
Looks like it's
over
opening
here.
a new tab.
Yep.
Yeah. Great. So we have 4 compliance charts to review. All of them will be reviewed in the same way that the size of the bars equates to the count of cases in that section. So although the 0% parenting time payment received bar is very large, that means that the majority of cases, there's about 150 cases that fall into that category. But if you want to see the percentage of the compliance, you need to read the percentage next to the bar. Another example would be that over 50% parenting time, there's only 1 case, but there's 100% compliance. And as Lucci already noted, our definition of compliance is just 1 payment being received within the time frame. So for parenting time, there was a slight increase in trend of compliance as the parenting time increased.
And I forgot to say it at the beginning, but if you're looking at that first section where you're just looking at the overall numbers, by our measure just within this report, there was about an 80% compliance rate with all the cases in general. So that tells you then if you look at cases with no parenting time using that same measure of compliance, it was about 73% of the cases received a payment. So that 80% is helpful, just knowing, okay, this group was less than, all the other groups were above, some significantly above. You want to jump to the next one?
Yeah. We also looked at total joint children, and the compliance rate essentially stayed the same no matter how many joint children there were. So 1 joint child was 80% compliance, 2 joint children was 82%, and 3 or more was 80% compliance. This one, we are looking at the paying parent income, and we have the groups on the left. We stuck around $1,000 monthly, but we also separated the self-support reserve and lowest minimum wage. Lucci, do you want to explain the self-support reserve?
Yes. So, and this is something that we want to look at as part of the income work group. So income work group folks, pay extra attention, but self-support reserve is based on the federal poverty guideline, and it's the amount we say, okay, this, at least this much has to remain available to the parent who's going to pay support, or both parents really, when we're calculating the support amount. So during the sample time, it was $1,418 per month. And so parents whose income was at or below the self-support reserve, they probably had $100 minimum order, unless other conditions applied. But that's what this section is. And then the second section, we took everyone who is above the self-support reserve but below the lowest minimum wage, and separated those out. And then after that, we tried to just kind of lump them together as in larger groups to make it easier to read.
Yeah. And the least amount of cases sat in the self-support reserve, and the most amount of cases sat at potential minimum wage. And otherwise, there is a upward trend of compliance, which we would expect to see. The more income you have, the more you comply with the order. But what we think is the most interesting is the first two groups and where they're sitting at the count of cases at minimum wage and the self-support reserve.
All right, and then this one we couldn't draw a ton of conclusions to, but Annie can give us a little bit more.
Yeah, I agree. I think that it's still interesting, though. We have spoken about changing the compliance definition to a more accurate representation of what payments are being received, but also maybe we need to change the court ordered amount groups. So this goes by about $100 for the groupings. And if you look at the compliance percentages, it kind of raises in groups. So if you look at the first three, it goes from 70 to 85. And then the next three, it jumps back down 70 and goes up to 100. And then it jumps back down and goes up. So this graph may not give lots of compliance trends, but it does show that maybe we should change the court ordered amount groups, or maybe look at these groups with the income groups. Christine, do you have a question?
And just one quick question about what you can't, could a payment, you said just one payment, could it have been like a claimed tax return fund or something? It could have any kind of fund that came in. Okay, thank you. So it doesn't necessarily mean compliance on the person's behalf, just
and that is a great point too, that in the future we would also like to look at where the payments are coming from, in addition to percentage of total compliance.
Overall, for the cases we enforce and within the program, we get about 70% of our payments through income withholding, and that's kind of just an automatic thing, and it slides right into place. So it's harder to say whether that's because someone was happy with the support amount, or if it was just that they have a job and we have issued an income withholding. I think that's the last chart in this section. When I've talked about this report with some other internal folks, we have really highlighted this compliance in new orders versus modifications. But Annie and Sabrina Owen and I kind of went through and really dug into that, and sadly found that it wasn't quite as exciting as it looked when we were first looking at the numbers. So when we first looked at it, we saw that the cases were split. 51% of the cases we looked at had a brand new order versus 49% having a modification of a previous order. And if we looked only at the new orders, we saw a 73% compliance rate, so lower than the average. And when we looked at the modifications, we saw prior to that modification it being around 75%, so consistent with the new orders, and afterwards jumping up to 88, and that seemed really significant. And we were pretty excited to say, like, what's going on with modifications? When we dug a little deeper, we found there was a pretty healthy number of orders that either went to or from zero. So maybe parents didn't want to have a child support obligation when they first split up, and then later we're like, you know what, we need this, or vice versa. Maybe, you know, children have changed households or things have changed within the family and they've modified to zero. When we took all of those out, the modifications and the new orders were much closer. So less noteworthy than we thought it was in here. We looked at family violence indicators and didn't find a ton of significant information to share with y'all, because really there weren't a ton of cases where either a paying parent, a receiving parent, or a child had indicated that there were safety concerns and they needed to have extra precautions. So we didn't truly see trends within this group. And then, oh yeah, the healthcare coverage, just briefly, again, we didn't find particularly helpful conclusions for the healthcare coverage group out of this, because we were only really looking at what got ordered, not what was being provided. And certainly the majority of the orders we looked at in all the different income groups did not have healthcare coverage available at the time the order was entered, based on what we could determine reading the orders. Is there anything else, Annie, that I'm forgetting to say about this one?
No,
Okay.
good.
So, and we kind of go through a little bit of our conclusions. Some of these are targeted more internally towards us and how we look at the guidelines, but I welcome questions and follow up from any of you, you know, now or later on if stuff occurs to you.
Thank you for going over that report. It's interesting every time we look at it. There's either some new thing that jumps out at us, or sharing it with additional people where Jeremy had a suggestion about potentially labeling it a little different. So I think that's helpful. And Trina had put in the chat about you know, a situation where payments are coming from income withholding, and yes, they're being made consistently, but also that the paying parent may not be happy about that. And as Lucci said, about 70% of our payments do come in by income withholding. The majority of those paying parents don't switch jobs just to avoid that, but that is something that happens occasionally, or people who just avoid the traditional employers to begin with, so that it's not a way to have it taken out by income withholding. I think we've mentioned it here before. We did have a bill last session that included reporting of independent contractors to try and catch some of those additional situations where someone may not be a true employee, but is still having some form of income coming in. And so we do look at topics like that, and sometimes come up with a legislative concept that we submit bills for to try and address some of those issues. So that's out there as well. So this report is posted on the Child Support Advisory Guidelines committee page, and I did include the link in the agenda plus the PDF. So that is something that you can, you know, go take another look at and see if you have specific questions. As Lucci said, as sort of the introduction for it, is this is one of the things that we have to do as when we get to sort of our final guidelines review report. It's one of the things that we had to look at. So that's part of what drove the need to do it. But I think it's also helpful of just trying to look at data in different ways and see either does it clearly show something to us, or is it like, well, we don't know what that's actually showing. We just know that that's what the data point is. And some of it may be we can follow up on those in the future and look at it and see if that helps us identify a trend that way. I see there's another comment. And so enforcement actions being needed in some cases. We do see results on some of those different things about license suspension and some of those things where that can be a way to get payments from someone. And in other cases, it's also not effective and just can drive them further underground, or more of an avoidance thing if they're able to do that. We have some internal work. We're going to be looking at our data on license suspension, not specific to the Guidelines Advisory Committee, but just looking at it based on some national data that's available there. Okay, I am not seeing any hands for questions on the report. So we are on schedule to do the work group updates. Oh, Keith, go ahead.
So I don't mean to mess up, but you know, this is newsworthy. The fact that 80% of people are paying their support award. wondering whether or not we shouldn't, let the world know that people largely are doing what they're supposed to do.
Thanks. I think yes, it is, and I don't know. I think part of that is even how we're defining compliance there, because right now that's based on a payment being received, and I don't have the current stats in front of me from our overall compliance numbers. And I don't know, Annie, that you necessarily have them, but yeah, I think some of those things of how do we highlight that? And I think it is something that we try to promote in various ways of like, a lot of parents really have their kids' best interests at heart and are trying to figure out the best way to support them financially, emotionally, physically, all of those things, and how do they tie on. It's not always about the money, but it can be a factor of if there isn't enough money to get them food and medical and those things that give them a stable place to be is one factor. But yeah, looking at what successes can we highlight? Okay. Yeah, thanks, Annie. All right, so first up on the work group updates, we have healthcare coverage and childcare costs. And I saw, yeah, Alicia, I think that's you handling it. Thank you.
Yes, that is no problem. Hi, everyone. So a quick recap of the most recent healthcare coverage and childcare costs work group that we had last week is we are continuing to discuss the healthcare coverage portion of our work group, and we ran through a guidelines calculation and discussed the impact of the reasonable and cost cap. And so there was a discussion of the current percentage the cap is calculated at, and some different approaches that we've historically taken, whether that's the current direction we have of the combination, or whether it was an individual cap that we looked at. Currently, we look at it from a combined reasonable cost cap, and that kind of allows more parties to have health insurance through employers. But it butted up a little bit with our previous discussions last month of private versus public healthcare coverage, and whether continuing to consider the need for a higher cap is still necessary. So we're going to sort of continue our discussions about that. We also talked about cash medical and the federal requirements and the statutory requirements to include those, and then also the child support program's current approach. And the group kind of landed on and had a lot of dialogue around wanting to make the direction in the public calculator a little more user-friendly for the public. And it can be kind of confusing on, there's a drop down that says yes, include, or no, don't. And what are some parameters around that, and to provide people some additional guidance. So those were the main things we discussed, and we're planning next month there was requests to continue to have discussions around the reasonable and cost cap, and then also to talk a little bit about an area we haven't discussed yet, which is like additional healthcare costs, like dental, vision, mental health, prescription, some of those things that we haven't really dived into yet. I think that is everything.
Thank you. And next up, we have the income.
Oh, Dawn, I'm sorry. I just saw, I think Judge Rain put in something in the chat asking us a question. I don't know if you want us to address it before we move on.
Yes, that would be great. So that was asking about the high deductible insurance coupled with a health savings account, which gives a parent a tax advantage.
You know, we haven't gotten into any conversations around the SHA. I know that when we were talking about reasonable and cost, some of we might have gotten a little close to deductibles, but we haven't talked about that directly. But we can make note of that for sure.
Yeah, this is Alex. I think that that's a great suggestion. We can definitely take it as the at our next meeting and kind of talk a little more about it, then report back next month.
Thank you.
All right, the income work group you had in your the meeting minutes were in your with your agenda, and our group had continued. It was our intention to kind of start our conversations focused on the use of potential income and imputed income in the current guideline rule. So to kind of prep ourselves for that, Krista brought us quite a bit of information about general hours worked nationally and what resources we can access to see that. Right now, when we don't have enough information about a parent's circumstances, we impute full-time minimum wage, and this data was kind of trying to help us see that that's not necessarily what the average hours worked by most people are. Not 40 hours. It's closer, I think, to 34 nationally and similar in Oregon. So we went through some of those numbers and have those, I believe, posted on the Guidelines Advisory Committee page as well. We also talked through as we wrapped up our last meeting in February, we were trying to differentiate how many cases we're talking about have parents who are on TANF receiving public assistance versus parents who are not, because one of the components we want to look at is what kind of income we allege for a parent on TANF. And so Krista and Annie went through quite a few numbers within our caseload. So we found that we get about 80 orders a month through the court system where we're not providing services, where there is no referral and no requirement for the program to provide services. And so that gives maybe a little bit of a picture of how many orders are out there through the court system on a regular basis. We also looked at how much of the child support program's caseload is originating out of TANF cases versus through the courts. And so we found that 13% of the cases were current assistance cases where a parent is currently receiving TANF with the children. 56% were former assistance cases where the case came to us because someone was receiving TANF, and then 30% were never assistance cases. And that was just trying to give everyone a picture of kind of the overall demographics of our caseload. And then we moved into our discussion on potential income. And I think we mainly tried to articulate what problem we're solving, and that income paper on the website lays it out, but trying to drill down whether we're looking at how we're determining potential income overall, or really how we're determining income in maybe some more specific scenarios. And we haven't, I don't think, finished that conversation yet, but the group keeps gravitating towards what income to allege for a parent receiving TANF. And I think that's where we're going to focus our energy in our next meeting. And Jeremy gave us a really good assignment that if folks are uncomfortable using minimum wage for a parent on TANF, we really need to think through what we would replace that with. So we all have homework to come up with some ideas. If we don't like that current scenario, what would we do instead? So that's going to be the focus in April.
Thank you. And the parenting time credit.
Mike, did you want me to take that?
Am I on the agenda to take that?
I didn't assign anybody.
Oh, I think you had volunteered at one point to be the reporter outer, but that's okay. I can do it.
Thank you.
So we just met yesterday and we spent a good deal of time talking about the time sharing adjustment and the blocks of time and what constitutes an overnight or a half a day and things like that. We looked at some of how the other states do it, and it looks like the Tennessee model seems like one that we are more closely aligned to wanting to follow. And what else did we do? I'm scrolling through the minutes real quick here. We also talked about not wanting to restrict or put anything in rule that would make it be too restrictive, but to really keep it may, so that it would be more up to the fact finder. We also went through the recommendations from the paper and just kind of got a sense of where everybody lied. And the big takeaway for me was to either incorporate things into the rule just as clarifications, but mainly to stick with the status quo and not make major changes. And then for our next month meeting, we're going to try to have some proposed rule language so that we can, everybody can figure out if we're on the same page in terms of how we're going to put the blocks of time and stuff like that into the rule.
Thank you. Did anyone have any questions or comments? I'm not seeing any. We do have next on the agenda is roundtable. And so if anyone had a particular suggestion for a topic for the next meeting, we could take those here, or if there's something else that has come up that we need to talk about, we could do that. I'm not, oh, Keith?
I'm sorry. As to life insurance, there's some case law out there that suggests that a non-custodial, a custodial parent could be required to provide life insurance. The legislature created a statute that says life insurance is just to cover whatever the award is. And if you have a minor award or almost no award, I mean, there's a case that says, well, the court has the authority to do that, but no statutory authority for that. I'm not sure if we want to get involved with any legislative stuff or not, but it would certainly make sense that you know, if you have a substantial child support order and you pass away, then insurance covers that substantial amount. If you're a 50-50 share with the parent, suddenly your whole income and all your involvement is gone if you're dead, and the other parent has to pick up the full tab, and there may not be any insurance because, or maybe a very small amount. Maybe Social Security will help out some, but nothing. It'd be totally disparate from the person who had just a normal kind of child support order and life insurance to cover it. Again, not sure if we want to take up statutory stuff or not.
And Mike, am I remembering right? Was there a bill last session that had something to do with life insurance, but I think it was like if it was entered as part of a divorce decree, is that?
Yes, there was. Senator Gelser introduced it, and I believe it passed. It provides that at a certain point, you can ask to have the amount of life insurance you're required to carry reduced. And I think you know, it's when you get to be a certain age when the amount of remaining support that you're required to pay until the child ages out is significantly less than the amount of insurance that you're you know, required to carry, and a few other factors.
Okay. And
that's not the issue I'm talking about, though. The issue I'm talking about is when there's already a very small child support order because the parents have a 50-50 share, and there's either no child support order, and there is a court of appeals case that says that, yeah, you can do it, but really no legislation to back that up. And the legislation suggests that you're only covering what the child support order is. So if it's $10 a month, you know, you're not getting any life insurance of value for the other parent.
okay, but I think the cases where we've seen that is the judicial orders either in a divorce or it doesn't have to be a divorce, but the actual judicial orders, because it's not anything that child support currently would establish or enforce, if I'm remembering the circumstances right. Okay. But Judge Raines, your point is in the particularly in the shared situations. Is it case law or is there a statute already?
Well, I think the statute is in conflict with the case law. The statute says that it's only to cover the projected amount of child support that would be out there. And there's some case law saying that even if there's a joint custody agreement, that the court could order some life insurance, but it really needs to be fixed.
Okay. But we can try and look at that a little bit just to see. I don't I don't know if it would be within the purview, but we could at least see what the conflict is. Linda.
If David has a comment that relates to what Keith just said, that's fine, because mine was a different topic. Oh,
Different
okay.
topic. Okay.
Okay, I just wanted, I might be a dog with a bone here, but the two items that were from the last minutes, I'd like to make sure that we don't forget them. One is that there be a link regarding the child attending school information added to the annual notice. And the other was that there be some discussion about guidance when both parents should be ordered to pay child support for a child attending school. The rule said that it can be. I know the agency doesn't initiate that, but I still would like to see some guidance to parents about that.
Thank you. And our forms person, is Michelle Crystal on today? We do have the annual notice tracked to look at updates to that, which usually starts well in a couple of months because we get them finalized. So we will definitely look at adding it on there. And then I think the guidance we were looking at as potentially rule commentary and maybe something for the child attending school page. Maybe. Well, but yes, we've got them tracked and we will work on those. Thanks, Linda. David.
Yeah, I was going to ask in general, in the child support system, something that I heard that we lack for specific situations is we're not able to make prepayments for an entire year or 3 years in advance. And there is some self-employed people that maybe has a big chunk in a specific year and they would like to pay like 10 years in advance or until they become adults. Is that a possibility inside the system that that can be open to discussion or not? So pay pretty much the entire year.
I will
until they become adults.
Yeah, I will start and Mike or someone else can jump in. So a child support order is always subject to modification. So if somebody did prepay, they're prepaying based on the amount now, and that could change going up or down. We have a little bit of a system issue of when that happens. Do we just sit and hold the money? And we can't do that on a broad scale because we have federal regulations about dispersing the money within I believe it's 2 days. So we have some of those things of if we get it and we send it out, what happens in that way, or if we're just holding it. But there are some circumstances where people do that, but the problem is the order can change. So that's one issue. And I see Mike may have thought of something to bail me out there.
No, I mean, I was basically going to agree on the, we do have statutory authority in cases where a paying parent has paid too much to either refund the money or use it to offset future support. But that's when we've paid too much money to the receiving parent. We don't really have a systematic way on a broad scale to bank 10 years of support for like 1,000 different people and then each month go in and take 1 month of support out and send it. It just would be administratively burdensome. We do it on a small scale occasionally where we'll intercept. We got somebody who's never paid and we find out they're entitled to an inheritance. Sometimes we can persuade the court to give us the inheritance and we'll use it to pay their future support. So, we've got a handful of those kind of cases, David, but I think trying to implement it on a broader scale would, we might have to hire extra people to manage that. So.
Okay. I was thinking more like a trust, like kind of like what you guys have for retirement system. There's already a system in Oregon, which is your retirement, and maybe can be giving that big chunk in there so they can manage it and keep growing it at the same time, just remove whatever is needed based on the support. So at that point, the person can, be operating without any difficulty of going down or up. When it does on a specific scenario like, self-employed pretty much.
Mm-hmm. Yeah, and they definitely could set it up on their own, and I think Michelle actually put something in the chat for that. Yeah, we could chat with our financial services people, but I think the biggest risk is that if something happens to the order, then particularly if it's an overpayment type of thing, or people, the paying parent thinks like, oh, I've paid it, so you can't change it. Can be an issue that way. And I know sometimes when the child is getting closer to being age 18 or, up to 21 here, remembering back when I was a practicing attorney in Wisconsin, we would sometimes get the parent who was like, I just want to pay $10,000 and be done with this. And it's like, but the needs can change. So that can be part of the problem. But there have been ideas about, could you annualize a payment instead of making it be monthly also, because maybe the person gets a large amount of money at one time. Currently, that isn't how the system works for us, but even at the federal level, sometimes they look at changing the regulations about that. And the difficult part of that is if you wait until the end of the year and you get caught up, is that the child hasn't had that money throughout the year. But if it was a prepayment type of thing, which I think is what you started by suggesting, it at least could have that benefit of making sure that they got the money. So things to think about, but those are some of the barriers to it right now. But it's something to think about, or even having a suggestion of, if you're in this situation, here's how you could address it. I think maybe an education type of situation might be helpful.
Yeah, I actually stumbled into that with my ex trying to prepay something, and it created a big conversation of trying to figure out how to fix it so that they weren't showing us not in compliance, and we satisfied everything. So having that guidance up front probably would have helped.
Yeah, and I think sometimes what individuals do is if they're in that type of circumstance, sometimes they say, you know what, we're going to close our case with the child support program and go address that on their own. And then if they get to a situation where it's not happening, they come back to us and do something different. Not that we're encouraging people not to have a case with us, but if there are those types of arrangements and the parents have a good working relationship, sometimes that happens. But then if the receiving parent has some type of issue and then has to spend the money in advance, it also may not be there for the child when it's needed. So, okay. Any additional comments? We are at 11:24, so I think I'm not going to go back to do the calculations, the live running through of that today. I think we had a good conversation on that and can think about how to move forward with that best. If there aren't any additional comments, we will adjourn today's meeting and see you again in April. Okay, thanks. And we will send out the legislative information. Thanks.
Thank you.
Bye.